We're here with Jim Trusty, dare I say a former federal prosecutor, but a good one at that, and one of President Trump's lawyers in this preposterous document case. Jim, it's good to have you. I have a question, Jim. Have you ever seen a federal appellate panel move as quickly as the D.C. panel moved in the last 24 hours to uphold a decision by an Obama judge who resigned immediately after she issues her decision, retires, getting behind attorney-client privilege and demanding lawyers' notes? I've never seen anything like this. Have you?
I haven't. The speed is not a total surprise because you're talking about efforts at, emergency relief, and sometimes courts can be pretty fast-moving. But, it goes to the heart of the problem across the country right now when it involves President Trump, which is, is he being treated radically different than any other person subjected to an investigation? And I look no further than New York, and you kind of know the answer, but it's of concern. I think you have to take a long-run view of this thing and recognize that we need to have rule of law, not rule of political persuasion. So, believe me, I'm with you in terms of having those types of concerns about different people kind of closing ranks at the expense of President Trump because of who he is.
This judge Friday issues a sealed decision on information that is shared secretly between the prosecutors, your team, and the court. The court makes a decision. She puts it under seal. If it gets out, it can be extremely damaging to President Trump. It can affect the jury pool and so forth and so on. What does a lawyer like you, what does a lawyer like you do about that? Do you file some kind of a motion? Do you seek some kind of contempt? Do you demand some kind of investigation? She's gone now, the judge.
Well, so a couple of things, Mark. I mean, number one, no matter how many times people are leaking things to serve their own cause, I can't do it. I still am bound by the rules, even if it's on billboards across the country, what's happening in sealed proceedings. So I have to kind of tread carefully, and that's because I've grown up in a criminal justice system that takes that stuff seriously. The problem is when it's DOJ or FBI engaged in leaking, they're the same people that would have to investigate it. And so it's just realistically, it's not going to happen. And it would take some, real severe, I think, involvement from the court, really hard pushing by the court or even independent counsel to get to the point where you're talking about a leak investigation. I know I would welcome it because I think there's been an awful lot of really intentional, self-serving, violative behavior that's come out of this case. Again, goes back to that whole notion of a different system of justice when they're going after President Trump. So it's very frustrating. And let me just say this too, Mark. You mentioned ex parte. I mean, it's understood under the law that the prosecutors don't have to share everything when they're investigating somebody. They want to have grand jury secrecy, at least selectively in this case. And they're going to do things that aren't shared with the counsel from the other side of the equation or interested counsel. But, in something as historic as going after a candidate for the presidency, a current president authorizing that, and something as historic as piercing attorney-client privilege, which, although it happens, it's exceedingly rare. I mean, these are the types of things where, as attorneys for the president, we desperately want to know the facts, not just to know the facts, but to know how they're being presented or misrepresented. And I can tell you, we've had instances in this investigation, unfortunately, I can't talk about it specifically, but instances where we've caught them red-handed at being less than candid with the court. And so that's very frustrating to only get a glimpse and see things that are wrong and know that there's, bushels worth of paper that have other information.
My problem is if this prosecutor has all this information from Corcoran, has notes from Corcoran, it's almost like Corcoran's being forced to assist the prosecution at the direction of the judge. Then you have a panel on the circuit court. I didn't see who was on this panel because it's not in the media. And now you're going to have to go to the U.S. Supreme Court. I mean, how do you get your day in court? How do you have due process? There's a damn document case, for crying out loud. So I'm just wondering. People are asking me, and I don't know the answer.
Well, look, there's probably there's no silver bullet answer, I guess is the way I'd put it. There's not some, obvious, immediate, if they only filed this motion, everything would get cleared up. I mean, we're in this kind of strange territory of litigating a lot of things behind the scenes where there's not public disclosure, or at least not full public disclosure, and not even any sort of discovery. So, we on our side do our best to kind of find out what the government is learning, find out where they're headed, identify what their theories might be, and then fight where there's appropriate fights. And obviously, if you're talking about privileges, whether it's executive privilege, attorney-client privilege, work product privilege, these are important principles that shouldn't be thrown out just because it's a, quote, important case. And so, all I can tell your listeners is, we're on it. We're in the fight. We have a lot of daily struggles that we're dealing with in terms of making sure, or trying to make sure, that our client is treated like any other American. And we're going to stay in the fight. So, that's unfortunately, I'm kind of handcuffed in terms of how far I can get into the details. But, that's where we are. That's
understood. All right, so my next question to you, and first of all, I want to thank you for coming on the show. You're always great.
No, thank you.
You have many years of practice. I mean, have you ever seen overkill like this? I mean, it's not like the documents were sold to the enemy or burned in a fireplace or shredded. You had the Secret Service there. I mean, so seriously, you don't have to say yes or no. The reports that you're getting service staff and all kinds of people, more than one lawyer and everything. And I'm thinking, what are you chasing here? I know you're trying to concoct some obstruction thing, but isn't this overkill?
Yeah, I mean, look, my humble opinion is it's absolutely overkill. I was in some form of prosecutor's office for 27 years, and a good chunk of that dealing with, very serious violent crime, murders, RICO cases, kind of the creme de la creme of importance to the community. And I considered myself pretty aggressive, and I certainly have had opportunities to manage aggressive prosecutors over the years, but there's degree. And in this case, the flavoring we see, whether it's misleading the court, whether it's going after the attorneys left and right, going after the funding for the attorneys, putting people in grand jury on a minute's notice, making them come up from Florida. And we're not talking about a bunch of sophisticated businessmen or lawyers that are being dragged into the grand jury, although we have some of that. We're talking about dozens of people that have jobs like being the assistant groundskeeper at Mar-a-Lago or being an administrative assistant. I mean, people that are being intimidated by an FBI and a DOJ that's hell-bent on coming up with something to make President Donald Trump somehow distinguishable from everything that happened up in Delaware with Biden. So the level of intimidation, of lack of courtesy, of accusation, of grand jury, I think abuse in some instances, stepping over different privileges that apply for every other citizen. I mean, all of that is a picture of government excess, and it's because of who the target is.
Are you, if you can't answer, I get it. I'm trying to walk a fine line with you, too, here, because I know the situation you're in. So my question is, are you dealing with a prosecutor in the case of this Jack Smith who's independently making these decisions, or is he reporting, to the best of your knowledge, is he reporting to the Attorney General, the Deputy Attorney General, the Public Integrity Section that he used to run and so forth? Do you know how this is working right now or no?
A little yes and a little no. I mean, no, I don't have, kind of inside baseball insight to exactly what their chain of command or chain of communications are on any given issue. So, no, I don't know the daily operations. They have kind of an endless cast of prosecutors jumping in at different moments in this case. But I can tell you this. I mean, the overall structure is that, yes, Jack Smith has come in. He's come in midstream when it comes to the Mar-a-Lago investigation, and with a little bit of people that he's brought in, but mostly the exact same people that were investigating President Trump under Garland, and then suddenly there's a need for special counsel, but it's the same people just with different email addresses. So it's kind of a weird thing. It's not like Smith came in and created a whole new fresh team to look at it. He took the people that were already gung-ho working on this thing. But ultimately, all roads lead to the Attorney General. I mean, that is the guy that makes the decisions. That's the guy that went out and did a press conference for the first time in history to announce that he wanted a warrant and an inventory to be publicized to embarrass the president. And so, we're seeing a chain of command that sounds like it's special and separate and individualized away from political influence, but it's all ultimately landing on the Attorney General for the decision-making. And from everything I've seen of this Attorney General, that's a problem.
Bear with me. That was a sneeze. Anyway,
bless you.
Thank you, my friend. Where do we go from here? Or you don't know, since they're calling the shots. I mean, how complicated is it? I mean, it's not that complicated of a case. Why does he keep taking testimony? Why is he insisting? It's interesting, Jim. If you look at the case they lost against John Edwards, obviously having nothing to do with documents per se, the head of the public integrity section was Smith. And they were embarrassed by that case. One of the things they tried to do is what this Bragg is doing. They tried to make a case out of a non-existent law and change the law, and even the jury wouldn't buy it. In that case, the federal campaign law. And he lost that case. It was one count, not guilty, and 5 counts, hung jury, and then the Justice Department decided to drop the case. So you have overreach there. But one of the things he learned there was, one of the defenses Edwards had was, and I went back and read this, I was following the advice of my lawyers. And I think that's one of the reasons he went in there and wanted to get behind attorney-client privilege, because he's thinking from his perspective, I don't want to get burned again from this. What do you think?
It's an interesting theory. I guess the way I would frame it is, not dismissive of that at all, but maybe move in a slightly different direction. It is a unusually aggressive mode for any prosecutor to put in multiple attorneys that represent the person that they are investigating. And that's happened here. We're not bound by secrecy to not acknowledge that that's happened. So that's a starting point that's extremely aggressive, whether they're looking to ultimately disqualify attorneys that know the case or whether they're trying to just send a tough guy message. I don't know. But there's another thing that's kind of consistent with that we've seen, which, again, it's permissible under the law, but there's a lot of room for discretion in this world of prosecutors, and sometimes the discretion in this case seems to be missing. What they're doing is they're bringing in witnesses that they think might have something helpful or might want to have something helpful for President Trump, and they're trying to lock them out. In other words, they put them in grand jury, put them under oath, and try to get them to acknowledge that they don't have smoking gun information to exonerate the president. And it's a very aggressive technique. It's not unlawful, but it's just another one of these clues that there are no limits and no real exercises of discretion that are going to ever kick in on this case. They're going to be discourteous, aggressive, go to the limit because they feel like this is the target where they have to call in every sort of exercise of power they can to make it work. So, I don't know 100% about kind of the advice of counsel defense being locked out, but there's certainly instances where they're taking witnesses who are clearly friendly to the president and trying to put them before the grand jury to lock them into an account that's not as helpful.
Yeah, and a lot of people get scared and they're thinking, okay, they don't have counsel in there. Let me give them what they want. I don't want them coming after me. I'm just being honest about human behavior and so forth. And you're right, they're locking in their testimony, but he's going after the lawyers. He's going after the people who surround Donald Trump where he lives. It doesn't matter how low they are on the ladder, and he's making it very, very difficult to get the kind of representation. I mean, obviously you're superb, but I mean the kind of fulsome representation without intimidation that most individuals have a right to. And Jim, I want to thank you very, very much, and I'm very, very glad you're there for the president.
No, thanks, Mark. I appreciate it, and we'll keep hanging in there and fighting the fight. But thanks for shining a light on all this stuff.
All right. God bless you, my friend. Take care of yourself.